Hi, once again, this is Legal Matters. I'm Debbie Moraes. Welcome. This is the program that's been designed to address the timely, critical, and sometimes contentious matters that are facing businesses and consumers today. It's legal information, practical solutions, and straight talk about a wide variety of topics that will affect your home and work life. Once again, we welcome our sponsors from Bazar, Grasso law firm in East Providence, Jackie Grasso to my left, and to her left, David Bazar. Today's topic is mediation. Reasonable, win-win solutions. No wonder it's growing in popularity. It's great if it works. What does it take to make it work? When does it work? Where? How? We thought it'd be a good idea to have our lawyers weigh in on it. It just so happens that our lawyers are also trained mediators. So, since it's growing in popularity, Jackie, David, tell us a little bit about what the process is and who's likely to use it.
You want to start, Jackie?
My mediation training is in domestic relations, so anything family court related, most of the time what I will do is just divorce cases. Who's likely to participate? Husband, wife, spouse, whomever, as long as they're legally married. But in some cases we can mediate custody disputes if they're not married in a paternity case. It's a lot less labor intensive because everything that you're doing involves two people who are willing to participate versus a plaintiff and a defendant that would normally litigate in court. So it is less labor intensive and it's also less costly for them to do it. And it's private, so everything is done behind closed doors and you're not in an open courtroom, which, as you know, is a public forum. So any airing out of dirty laundry would happen in a private setting. And most people tend to choose that route over dealing with it in an open courtroom.
Certainly sounds smart. I guess divorces are what most people are familiar with mediation. There are other kinds, though, certainly.
Mediation can be used as alternative dispute resolution for any type of case that would otherwise be in court. Superior Court actually requires that you either go through arbitration or many attorneys opt for mediation as the form of alternative dispute resolution that you would use there. Federal court has a federal court mediator who gets assigned cases at times when the judges decide that's the best form of alternative dispute resolution to use. So every case where there's a dispute, mediation is a possibility for resolving that dispute. Now we can talk about mediation in terms of different types of court cases and get some specific information on that, but remember mediation is also used in labor situations, it's used in baseball for certain situations, so it has applicability to a wide variety of types of cases.
It certainly makes sense that some things wouldn't necessarily be about legal matters, but certainly, as this program is, but certainly is worthy of discussion and dispute and debate. And if it's contract and labor law, it sounds like there's an awful lot that seems to be growing in popularity. People would rather talk with two rather than pay the money and take the time. Tell us about the process. How does it actually start? Do two people come to you at once, the two warring factions, or how does that work?
Well, it's going to depend on what type of case we're talking about.
Yeah.
So let's talk about family disputes first and divorces. Jackie's done a number of these, I've done a number of them. If you want, I'll give you a little bit of the intro that I would give those folks, and then Jackie can take you through some of the specifics as what we would deal with.
Mock mediation, here we
go,
go, David.
Yeah, when someone comes in, I explain to them, here are some of the advantages Jackie was talking about with mediation. The main and first advantage is, especially in a divorce situation, is the way I operate with my mediations is I have the people talk to each other initially. And what we're trying to do is actually get them not only to talk to each other, but to listen to each other. And the purpose is to increase the communication, but also to get them to understand each other's side of each issue. And then let them determine the resolution of it. And what I always tell folks is, the two of you are better off deciding a resolution of an issue between yourselves rather than letting some judge who doesn't know you make that decision. The second thing about it, and what Jackie was referring to, is cost. Divorces today, with any complications to it or any difficulty, you're going to look at paying an attorney a retainer of $5,000 to $10,000, and that's for each of you. And if it's contested and goes through a trial or anything, you're going to spend much more than that. Mediation, some folks will charge by the session, $500, $750, maybe $1,000 a session. I've seen some mediators even saying, I'll charge you a flat fee, as many sessions as it takes. And so after that's done, then you have to take it to an attorney to get it put through as a divorce, but most attorneys you can find out there that might charge you $1,500, $2,000, or even less to put through a mediated divorce.
And sometimes the cost would be determined by the length of the marriage, the value of their assets, if there are no children involved, if it's a 2 or 3 year marriage. We generally will do that for a flat fee.
Right.
If it's a long-term marriage and they've acquired significant assets, well, obviously there's going to be more time involved with that. There may be some complicated issues like pensions, or trust funds, and gifts, inheritances. So that would take a little bit more time. It would be priced a little bit higher than that.
So, assuming that just as if someone were going to go to court as warring partners in a divorce situation, understandably, if two are unhappy with each other, they bring anger, hurt, resentment, whatever those other emotions are. Are you serving generally as referees to quash that, or at least to diffuse that a little bit before you get down to the business of making your itemized lists and comparing notes?
We do, in some cases, yeah, we have to serve as referees, but one of the determinations we make at the outset is if two people have a difficult time communicating or a session ends up in a yelling session, what works the best is to separate the parties, okay? Put one in one room, put one in another room. That's what works the best, because it gives one party the ability to at least speak their mind privately to the mediator. Maybe that party wants something said to the mediator that they don't want to be said to their spouse. And sometimes that works.
Right.
If there's a domestic violence situation involved, absolutely, it's probably not something we want to get involved
Right.
with.
That's something a mediator wouldn't,
It's something I
Now,
wouldn't deal with. Okay.
most cases, see, for mediation to work, there has to be complete disclosure of every asset and all the issues, and there can't be one party coming in afraid of the other party or unable to deal with the other party on an equal footing. A mediator can deal with some things, but if there's domestic violence or anything of that nature in the past where one party may have control over the other party, mediation won't work under those circumstances.
We're pretty astute. We can sniff out any situation where we believe one party is trying to control the other party, and typically what would happen is the spouse would answer questions for the other spouse. One spouse would sit there and not say much. You would get the sense as to who would be handling the money throughout the marriage. We can pick that up quite quickly, and if we feel as though there's someone trying to take control, what I would do is just separate them. No malice intended, just to separate the parties, because it would let the mediation go through much smoothly.
and if you're doing this, how would you know whether or not there's been full disclosure on both parts if you're not summoning all of the documents, every email, phone record, et cetera, as you might in other cases? How would you know it up front?
Here's the process and what we do. It's the first meeting, we lay out how the process works. We explain that, as Jackie was saying, that we'll meet together. But then we call it a caucus. You separate. I do that in every mediation.
Private caucus?
Private caucus, where I'm going to speak to each of them to make sure there isn't anything, whether I get the sense that there is or there isn't. If they've agreed to everything as we're going through this, at the end, I'll still break them up just to make sure that one party doesn't have something else to tell me that they didn't want to say in front of the other party, or that there's any other information that I need to know. So we do that as part of the explanation of how it works. Then what I'll tell them is that you have to bring in all the documents that show what your assets are, the statements from the banks, the IRA accounts, the pension account information, medical information, everything that you have, tax returns, so that we can go through it and make sure that we're not missing anything, number one, and that we think there's full disclosure. What I also tell folks is that although Jackie and I are lawyers, that they should consult with a lawyer as we go through the process, because we're not there to give them legal advice, we're there to help them come to a resolution. Certain things that are, just generally well known as we go through it, we may talk about, like how child support's calculated, that type of thing. But in general, if there's an issue about taxes, I tell them, go talk to an accountant. If there's an issue about value of real estate, go talk to a real estate appraiser or an expert. Whatever expertise is needed, they should go out and do that. And they can bring those folks into the mediation if it's necessary. Usually it's not, but they should understand what their rights are and what the information they need to have is.
So let me just pick up on something that you said a moment ago, which was that you might actually suggest that they bring in a lawyer. And if the purpose of having a mediator is to save time and money and not get into an accelerated fight. Sometimes lawyers do that, not that I want to say that, but if they're going to bring in a lawyer, doesn't that defeat the purpose of you having a mediator to save money?
Well, 99% of the time, they physically don't bring in a lawyer.
Okay.
For some larger cases, and David has been involved in multi-million-dollar cases, it necessitates a lawyer being there. And in his particular case, there were 5 lawyers on each side, and he served as a mediator.
Right.
He can tell you about that. But what I do also, if I don't serve as a mediator, I will have the client come in and consult with me and give me a list of issues that they are seeking in the mediation, and I may give them suggestions. They may go to the mediation,
Okay.
come back with what the mediator has suggested, and then I might tell them, no, I think you should get X, Y, and Z. In my experience is the clients are much more comfortable with that, and I only charge them an hourly rate, so I'm not going to charge them a $5,000 retainer if all they're doing is consulting with me. And then if normally what would happen is I would prepare the divorce paperwork, because the mediators cannot prepare divorce paperwork. I would prepare the divorce paperwork and the settlement agreement based on a written agreement that the mediator puts forth, and then I would go to court with the parties.
So at the end of a session, at the end of the mediation process, the parties end up with a memorandum of understanding, which is just a written form of their agreement. But that's not what you would take to court. What Jackie's saying is a lawyer, whether Jackie's serving as their advisor and then the attorney to put it through at the end, would then have to fill out the paperwork for a divorce and would have to do a property settlement agreement or a form that would be used as a contract for the court case. So you end up with an agreement, but it then has to be brought to the court in a form that the court will approve.
And before you reach that agreement, would you likely be in the place where the two are in the room and you make suggestions about how this one gives up guns for butter, or what might look like a reasonable way to negotiate or settle it out?
So the reason I want them
Reframing
to
it?
go to an attorney, if there's a lot of assets or there are issues that they need to understand, is the parties can come to any agreement they want. And as one of our mediator trainers told us, they can give up the farm as long as they know they're giving up the farm. They have to know what their rights are and then make whatever agreement they want. So what I do is I just go through the process with them. And let's take an easier example of how you can bring people together. Children in custody, in visitation. So when they're really at odds with each other, pounding on each other as to how they want to resolve that, I try to break them down and go step by step, starting with the premise, I would assume that both of you have just the child's best interest at heart. Let's start with that. Can we agree
Good
that that's a
ground
premise?
Always start with things you can agree on.
Agree on, exactly. So now we have this premise. We both have the child's best interest at heart. Why don't you want the child with the father on Wednesday night? And she might say, because I'm worried about school. And the father then might come back with, well, I understand that, and this is what I'm willing to do. And get them to start talking about it so they can come out to a solution that they both understand why they got there and why it's in the child's best interest.
So you might come up with not A or B, but rather C out of how that might work.
Correct.
Which is a good
Right.
and reasonable thing to consider.
And frankly, I try to get them to get to C, but sometimes you have to make a suggestion as you go along. But the real goal, and now different mediations work differently. In family court, to me, these types of cases, the real goal is to get them to get there. You prod them along a little bit, as opposed to Superior Court mediations. Now, we want lawyers there. They're cases that are usually in suit, usually personal injury cases, and we're just talking about dollars and what cases are valued at. And lawyers have a better understanding a lot of times as to what a case is worth than a client who's gone through the injury and thinks, you know, maybe they have an inflated value of what it is, or maybe they don't have any idea of what the value is.
On the domestic front, something not as rattling necessarily, although it might be as a divorce. Suppose you have two neighbors. One's complaining that the other has the outdoor lights shining too brightly and it's disturbing them. This isn't exactly a financial dispute, but and who knows, it's a nuisance, and who knows what motivated. There could be some other things that cause it. If you were likely to, would you be likely to mediate something like that? Obviously, it's not going to be in the thousands of dollars, I wouldn't imagine, but is that a reasonable thing to be mediated, or just too trifling if the two can't get along? How do you decide whether or not that's likely to be a kind of case that you might handle.
It's not something that I see in my career. If there is a contentious court case that's, being pursued, and it would be Superior Court in this case, and the judge recommends that they try mediation, that might be something that...
Yeah, any dispute, like I said before...
It's available to any case.
So,
any case.
Again, in that type of case, bring them in. Let's try to find out what the issue is, what's the underlying problem. I have the spotlight because we've had people break into the house before. Well, okay, but does it have to shine that way? Can it shine this way? You can resolve that. We have them with fences. I think neighbors and fences come up all the time.
Yes.
And I've actually mediated a case with brothers in probate court and fighting over assets in probate. So it really can resolve any dispute in any form.
Now, I understand with this growing popularity, such as it is with mediation, that mediation can also be somewhat preventative or prophylactic. Someone's going to enter into a new business partnership, for example. I'm doing this, I'm doing that. Those are two partners. Where would a mediator come and become involved? Would it be in how you'd settle the assets if you part company? What's the preventative measures that are involved with mediation if someone were to use it in a business application?
Well, preventative in the sense that maybe an attorney is representing a company where two partners are trying to come to a partnership agreement, and that attorney feels a conflict perhaps because of representation of the different parties. Maybe in that case, you could bring the parties to a mediator and say, all right, who's going to run the day-to-day operation? What are your responsibilities going to be? Frankly, I'd be a little concerned if I was going into a business
You'd
with a
have to
partner
involve a
where I
mediator.
needed a mediator.
Already. You wouldn't see that as a worthwhile thing and prophylactic. You'd be saying, we're already up on the wrong foot.
Yeah, although it can be helpful. I've never thought of it in those terms, but I can see where a mediator could be helpful. But frankly, as I said in family court setting, we're trying to get people to be able to talk to each other and understand what the issues are that from the other person's perspective. Hopefully, you wouldn't need that going into a business, but if you do, we can do that.
Okay, and as I mentioned at the outset, you two are lawyers, but you're also trained mediators. What are the advantages, or what's the difference in someone being a mediator, not a lawyer, and a mediator?
You don't have to be an attorney to be a mediator. On the domestic relations front, sometimes individuals choose lawyers that practice in that area because we have a background and a knowledge of the area. The difference may be one person who is just purely trained to mediate, to get two people on the same page. It may be a lot cheaper, but they get the same exact training that we do. Is to get a license, to be a licensed mediator. They don't have the background, the legal background, the training that we have.
Are there times when you are mediating a case, whether it was domestic divorce or otherwise, where you come to the conclusion, you two we can't do this as mediation, you two need to get lawyers? At that point, could you be one of their lawyers, or does it automatically go from out of your hands into now two other people because you have the full story from both sides? Conflict?
Here's the first part of that. Where two people have gone through mediation and do not resolve their issues, clearly the mediator can't represent either one of those parties because there's a conflict that they're fighting over, and there's information shared in mediation that is confidential, and the mediator cannot, in that instance, serve as the attorney. There's a bit of a dispute. We have taken the position, after discussing it and going through some issues with it, that the mediator who mediates a successful mediation, although the rules allow, as we read them, the mediator to represent one of the parties to put the divorce through, as long as there's disclosure and agreement and conflict of interest waivers signed, that can be done. We've taken the position that we're not going to do that because it doesn't sit well with us at this point.
If that's the case, what I do is I get a copy of the Rule of Ethical Responsibility that talks about conflicts, and I have my paralegal prepare it and attach it to an agreement, as David said, to represent. And I have them both sign an acknowledgement that they've read the rule and they know what the possible conflict could be, so that they're fully aware of what they're getting into when they hire us.
Yeah, and we think you can do that, but it's going to be our better practices, we feel.
Yeah, we don't do
that we
that
won't do
anymore.
that.
Yeah.
So picking up on this again, so while you might have found that there's a problem mediating a case, then if that happens, does it have to go to a suit, or could it go to yet another mediator and start over?
Sometimes they go to other mediators. That happens. I've served as a second mediator in the chain. It depends on
We're
what
just
the parties
exploring
want
the
to
issue.
do.
Good.
And
Okay.
frankly, to answer your question from our experience, I would say that probably 95% of the cases we've mediated have settled in mediation,
First time round.
first time
Yeah.
around. Those that haven't, in the domestic relations front and family court, have had attorneys involved in them already, and I'm not going to say the attorneys stopped them from resolving, but that there were big issues. The reason there were attorneys involved already, there were big issues in those cases, and sometimes those issues need to be decided by a judge, and that's what happened. And I can only think of 2 cases I've had that were in family court that didn't resolve.
Unfortunately, there are an awful lot of cases in family court. Makes sense that judges might say, we'd like to see things more in mediation rather than...
Well, sometimes, the
protract.
judge would suggest it before they
Yeah.
embark upon a
One of the
a trial.
cases I mediated had already been in suit,
Yeah.
family court cases, and came to me as a mediator while the case was pending.
On what cases would you find that a judge might mandate mediation? Is that ever the case?
Sometimes,
Whether
well,
business or family court?
Let's
or
back up.
however?
If 2 parties file a miscellaneous complaint in family court, that means they're unmarried. So if it's a paternity case, a complaint for custody or visitation, by virtue of the fact that they're not married, we have a rule in Providence Family Court that makes mediation mandatory before the parties can actually get in front of a judge. So as soon as the court gets notice that a case has been filed, then the parties will, and the attorneys, if there are one, will get a letter from the court mediation program, and they will actually schedule mediation for both of them to attend, and they do suggest that the lawyers not attend. And it doesn't cost them any money to have a court mediator. And then there's also sometimes when the judge will have the same court mediators talk to parties in a divorce. Doesn't
Right.
happen that much.
Right, and it's not required in that situation. As Jackie said, the rule is you have to go to mediation
It's
on
mandatory.
the M cases, as we call them.
Yeah, miscellaneous.
Miscellaneous.
Is that equally true in business cases, that there would be occasions when a judge would say, I don't want to have this be in court, I really want you to go to
They can.
mediation?
But
instead?
oftentimes, if it's a contract dispute,
Contract
they might
labor?
have the requirement right in the contract, either arbitration or mediation.
Yeah, that's frequent now. If you sign a complicated contract, even I've seen it in leases, that the parties agree to go to arbitration in lieu of court.
Explain that a little bit. You mentioned at the top of the session, alternative
Dispute
resolution. There's mediation, there's also arbitration, non-binding arbitration. Go through the
Okay.
alternatives a
All
little
right.
bit, if you would.
So, in fact, many contracts, as we were saying, require arbitration, and there's the American Arbitration Association, and there are many forms of arbitration. So, in Superior Court in Rhode Island, if you file a lawsuit, you're required to go to, in most instances, court-annexed arbitration, which is a process. The court has a list of arbitrators. I happen to be on that list, where you can either pick someone from the list, or the court will send you a list of 5 and you can strike names and have a person arbitrate the case, which is a mini trial. You go in, you present your case, the other side presents their case, you make arguments, then the arbitrator writes a decision. You don't,
Period.
Period. You don't have any input into how that judge is going to decide, the arbitrator, other than the evidence you produce. So it's different from mediation, where you control the outcome. The arbitrator has the final say. Now, this court-annexed arbitration program, if you don't like the result, you can pay a fee and have it sent right back to Superior Court and continue on with your case. There's also binding arbitration, where the parties enter into an agreement as to that whatever the arbitrator decides is final. It can be binding high-low arbitration, which is you agree that the highest award that you're going to pay, if you're the person paying, is X, no matter what the arbitrator awards, and the lowest is Y, no matter what the arbitrator awards, and anything in between you would pay. So that gives the plaintiff, in that case, the guarantee of getting at least a certain
X,
amount,
whatever.
and the person paying, usually the insurance company, the protection of knowing they're not going to pay anything more than the high. Another kind of arbitration, which is very rarely used here these days, we call baseball arbitration, where each side submits a number. that the arbitrator can pick from, the high number or the low number, nothing in between.
Nothing in between.
Right, and that's what baseball arbitration is. The player submits for his salary, I want $1.5 million for next year, and the team says, we're only willing to pay $750. Then you go in and you present to the arbitrator your reasons for what it is, and he has to pick one or the other.
Now, when you have arbitration, binding or non-binding, do you always have legal representation?
In the Superior Court setting, yes.
You should.
If you have lawyers.
I actually arbitrated a case from court annexed arbitration where the plaintiff, was pro se. He had a lawyer when the case started. I guess the case unfolded in a way that the lawyer either didn't expect or wasn't happy with, withdrew. So that fellow came in, and I had him present his case like any other lawyer representing a person would do, and I made a decision based on the evidence he presented and the defense that the attorney for the defendant presented.
There's some personal injury arbitration. You can actually bring in your own arbitrator. So we would have 3 arbitrators. The plaintiff would pick his arbitrator, the defendant would pick their arbitrator, and then both plaintiff and defendant would pick a neutral arbitrator.
Right.
So you do have some representation.
That's
It
called
tends
a-
to be expensive.
It's a 3-panel arbitration, and there are certain cases that almost require that. Uninsured motorist cases through your own policy sometimes do. Different types of cases where what happens is the plaintiff's attorney or the plaintiff has picked an arbitrator who's really going to, in the deliberations, push for his side of the case,
Sure.
and then the defendant's arbitrator for their side. And they try to come to an agreement every time, but if they can't, then that neutral arbitrator is going to be the one who has to side with one or the other.
Well, with this growing interest in it, there are many people who might be considering becoming mediators. What kind of training, where does one go to receive training versus arbitration?
Roger Williams
Yes.
has a program for trained mediators. Massachusetts Continual Legal Education, they run a program a couple times to train mediators and get certified.
How long is the program?
It took us a couple months in Rhode
Yeah,
Island.
well,
Because you were lawyers?
No.
No, because of the timing.
Yeah,
of,
they didn't meet like
schedule.
every day.
Yeah.
It was weekends, as I recall.
Yeah, because of yeah. And you don't have to be a lawyer to be a mediator, as I
Right.
said earlier. So
And
as long as you're
there's
certified.
a collaborative law group out
Yeah,
of
that's
Boston.
going to
that-
become popular.
Yeah.
It's a
Explain
future.
collaborative law a little bit.
Well, it's kind of like the mediation, where the parties agree at the outset, instead of filing a lawsuit, they're going to handle the case in a collaborative way, where everything would be done in a private setting. And, but they have to agree to that in writing up front. And I see that the nature of the legal practice going that way. There are a lot
At
of
least
lawyers
for
that do
family
that.
court.
Yeah,
Encouraging.
yeah.
Certainly
It is.
encouraging.
It's
Well,
very
well, the
encouraging.
point is, in family court, you usually already have enough contention already, so
Yeah.
let's take some of that out of the...
Diffuse it a bit.
Yes.
People who might want to be community arbitrators in a church setting, they could likely do that. Is it likely that they would need to go through a 2-month program, or do they just happen to have good people skills and say, I can mediate this
It would be
problem?
better to be trained, because there are certain things that we thought we might have known going in, that we picked up some additional things, a way of dealing with things such as, I talked about listening. So as a mediator, sometimes if I think one party's not listening, I've learned to take what that other person said and say, now, I think what you're saying is X, Y, and Z, for the purpose of that other side knowing.
Thank you for tuning in. Our discussion of legal matters will continue. Please stay tuned.